Hello, everyone, and thank you for joining us today at our Professional Focus webcast with Flaxman Partners. I'm Catherine Kennett, Policy and Public Affairs Manager at the Chartered Insurance Institute, and I would like to welcome you all to our session on claims-made policies, which is our second webinar in a series of 3 titled In Denial, Claim Denied. This, the second webinar, will take a close look at the definition of circumstances which may give rise to a claim, how to recognise them and what to do. We will include a look at mistakes often made by the insured in trying to fend off claims themselves and how the broker should be available to assist the insured without putting themselves at risk. We have with us online again today Roger Flaxman, Chair and Principal Consultant, and Michael Wilson, Director at Flaxman Partners, who are delivering the content on this series and, as always, are a very knowledgeable duo. There will be time for questions at the end of the presentation, so please feel free to use the question box you can see on your screen. And we will work through these once the webcast is complete. Any questions not answered in today's session will be taken offline and answered in the future. Without further ado, I'm now going to hand over to Flaxman's.
Well, good morning and welcome once again. I'm Roger Flaxman, and with me as ever is my senior consultant, Michael Wilson. Now, last month we introduced you to this rather vexing topic of claims-made insurances and how they work. This time we're going to look at some of the practical issues that arise, and with particular reference to notifications of claims. Now, the overarching problem with claims-made policies has, for all of my working life, been the fear that the policyholder has in making that notification, because the penalties for making a notification can sometimes be severe. For example, the insurer says, well, if you've made a notification, you must be guilty, I'm going to put the price up, or I'm not going to offer a renewal. Now, I'm saying that to exaggerate it. By no means every insurer does it, but when it happens, it can be cataclysmic. And very often when I'm consulting with policyholders and professional bodies, this is the thing that comes up time and time again, is that our clients are frightened of notification because of the consequences of doing so. Now, this webinar is entitled In Denial, and there's a reason for that. The natural human reaction to being told you've made a mistake is to deny it and to say, oh, no, there's nothing to do with me. Very rarely will you hear somebody say, oh, yes, I'm quite right, I've made a mistake there, so what can I do to help you? That's pretty much in la-la land. So most people say, I say most, a lot of people will say, oh, no, I can't be held responsible for that. I can't be held negligent for that. Well, the first thing I'd say, it doesn't matter whether you can be held negligent. The question is, somebody can accuse you of negligence and can require you to defend yourself. And that actually is the most important part of the insurance policy, is the defence. Now, going into denial as a policyholder is probably the deepest elephant trap which you can fall into, because it can be a very, very expensive mistake. Invariably, I would say the insured's denial will sooner or later be exposed by a third party that wants to make the complaint. And the reason that happens is that when people are upset by something, very often they get a bee in their bonnet that they're not going to let it go. And they'll go along to a lawyer, and the lawyer will say, well, okay, yes, I'll take this on and we'll make these allegations and see what sticks. The main reason for people wanting to do that, funnily enough, is money. But it's not always money. In fact, I've just only recently finished a case which had to go through the court, sadly, but it was all about the claimant wanting justice. And actually, in this particular person's case, he wanted retribution. He was so angry about what happened to him, and this was in a building matter, construction matter. And very often, the claimant will overlook all the sensible things in life, of the stress of making the claim, the cost, the time, and they will just plough on regardless. Now, if you're a policyholder, my word, you need some protection, and you're never, ever going to be your own best advisor. Now, insurers of liability know all there is to know about litigation, what I call the frailties of humankind in litigation. And so, in return for agreeing to offer insurance protection, they are undoubtedly entitled to require the insured to tell them immediately that they are aware of what is known as a circumstance. There is no doubt about that. The insurer is entitled to know as soon as possible that there may be a situation that could give rise to a claim. So let's make a start. Now, having put you in the frame of that's where we're coming from, Mike, would you like to kick off with some learning objectives?
Yes, pardon me. Thank you for that introduction, Roger. Yes, I'll just read through the learning objectives for this morning. It's to understand the two meanings of claim, to address the usual meaning of circumstance or circumstances, to consider further the timing and detail of the claims made, notification of claims, and potential claims, to appreciate the usual reasons why an insured might be slow to notify, and to examine the consequences of a late notification. So those are the learning objectives. So let's just have a look at the meaning of claims, because we could fall into the trap of using the word claim somewhat loosely. And when we're looking at these things, there are in effect two meanings of claim. So the first meaning of claim for somebody who, for instance, holds a professional indemnity policy, that would be a claim for indemnity under the policy. So that's the policyholder's own claim for indemnity under his own policy. The other meaning of claim, which would often be with a capital C, will be the allegation being made by the insured client against the policyholder. So that's the two meanings of claim. So if you find yourself advising policyholders about claims, it's useful sometimes to draw the distinction between the two meanings of claim. Now let's look at the definition of claim under the policy. This is just a sample definition taken from a policy that we were looking at recently. You can read that for yourself. Typically, a claim is made by a solicitor on behalf of a third party, but it need not be that formal. And this is part of the skill of identifying what a claim is. A claim could be a claim way before a solicitor is even involved. A third party writing a letter or an email can also make a claim with a capital C as defined in the policy, and so it should be treated as such at those early stages. And of course, as soon as anything comes in that could be described as a claim or a warning of a claim, requires the immediate attention by the recipient, and that means telling the insurer. And then once that's been done, the policyholder would normally assist their own insurers, maybe through an appointed loss adjuster or a solicitor, because as Roger has already mentioned, for the policyholder, sometimes the most valuable part of this process is the defence, which is provided for you under the policy. Um, Incidentally, just in passing, if you have a policyholder who is FCA registered, such as a claims management company or even a broker, it's important that that policyholder integrates their complaints system under the FCA rules with their professional indemnity arrangements, because sometimes you can find yourself dealing with something under the complaints process and you might have forgotten that maybe that's something that you might require indemnity under your policy for. So it's quite important to integrate those two aspects. Roger, could you, I know you've often grappled with the definition of circumstances, particularly through the expert work that you do. Could you just run through the definition of what a circumstance is, please?
Yes. Well, a circumstance is an expression which has been coined effectively. I mean, I know when it was coined, it was around about the 1960s. It was an expression to say, well, we want that thing when something has gone wrong that might give rise to a claim. And for all my working life, I've come into contact with people and say, well, isn't there a better definition of what is and what isn't a circumstance? And the answer is, no, there isn't. There really isn't. You know, a circumstance, I would say this, I'm going to put it to you like this. A circumstance is a situation. It's a situation that you're not expected to be in, but you find yourself in, and it requires you to get out of it or do something about it. So in very simple terms, when somebody who's, if you like, a professional advisor or anybody that has a duty to give advice or responsibility, when they take on the client, they say, yeah, we know how to do that, blah, 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 and it'll cost you this amount of money and blah, 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 blah. And then suddenly something goes wrong. Now, it might be it goes wrong because something else happens or the client changes the rules of the game, adds something in, is not disclosed something. There's all kinds of things that can go wrong. The point is, if a situation arises where the journey that you're on is interrupted by something that you didn't expect, with the benefit of hindsight, almost any competent lawyer, that was a circumstance that may give rise to a claim. Because if something doesn't go right, you can't say it may or it will not give rise to a claim. So what I'm suggesting to you is this. Don't get hung up on what is and what isn't a circumstance in the definition, because I can assure you, if anybody knows this, Michael and I do, whatever you say, the legal profession will say, oh, no, but in this situation, it's different. So actually look at it like this. If there is a situation that isn't going to plan and there's a bit of a complaint or a bit of a hiatus, then actually the chances are it's a circumstance which may give rise to a claim. Now, of course, the big problem in real life is that lots of things don't go to plan, but it doesn't necessarily mean it's going to give rise to a claim. And very often when things go wrong in a job or whatever, you can put them right. For example, I was watching a job the other day. Actually, one of my neighbours, they're having some building work done. And I noticed, as I was walking past the house, that shouldn't be there. They've put down the first foundation of a new brick wall, and they've put it. I know where it's supposed to go, and it's not there. It's about 2 feet away. So anyway, I know this chap well enough, and I went and told him. I said, "Why are you doing that?" He said, "Well, is that wrong?" I said, "Well, yeah, it is." Anyway, the bottom line is it's having to be done again. Now that's going to cost them a lot of money, a lot of time, and a lot of money, but should the builder or the architect that's designing this, should they notify that as a circumstance? This is where it becomes, frankly, it's not a position I'm going to give advice on, except on specific facts. But the fundamental point is anything which could give rise to a claim can be determined to be a circumstance which may give rise to a claim. That's the point I'm driving home here. Now, I want you also to realise that a claim and a circumstance are two different things. We've already explained what a claim is. And when you look at our fact sheet, you'll find it's quite clearly written out in there. And I do recommend that after the webinar, you do get the fact sheet, because it will consolidate what we're saying in very precise terms. But a claim is when somebody has decided they're going to make a claim, or they've made a threat or an intimation of a threat. That's a claim. A circumstance is something where at the time possibly nobody said anything. There might have been an implication. There might have been somebody sort of shouting about something and saying, well, but fundamentally most people will know, they should know, or should be able to recognise when something's happened that, if it gets worse, could be quite serious. Now, that's really all there is to say about the definition of circumstance at the moment. It's in a summary, it's a situation, something that occurs that is out of the ordinary. And so I think, Mike.
Well, Roger, can I just highlight that one difficulty that often arises is the different definitions contained within different policies as to whether the circumstance is something that may or might or could, yes, or is likely, yes, to. So we're not going to get involved with that today, but that is a specific issue, yeah, that we're going to cover in part 3 of this.
We're going to cover that next time. And just by way of advanced warning, in the last of the 3 of these webinars, we're going to touch on 2 or 3 specific things next time, but we're going to leave a lot more time for questions, because a lot of people have said we'd really like to discuss some of these things. So we're going to probably cover the topics in about a third of the time, and then give you all the time, the rest of the hour, to just ask questions and understand what's been going on. With regard to the expressions may, might, could, or are likely give rise to a claim, in my opinion, our opinion, it's academic. It's academic as far as the insured is concerned. The law has made distinctions with those words. I would say that you cannot afford to trust the word likely, so I won't notify it, because the threshold is something that only the court can talk about, not anybody else.
Well, Mike, I think we will touch on that next time.
We'll talk about it next week,
Roger. Just one thing I would like to add from my experience is that sometimes a circumstance is totally unrelated to anything that the insured's client has said, or any expression of dissatisfaction. And it might be that the policyholder himself has noticed that he's made an error that his client is totally unaware of. So one example might be a solicitor who realizes he's missed an important deadline. Now, yes, the client is perhaps unaware of it. The solicitor might take the view that although he's missed a deadline, in actual fact, it's not like to make a material difference to the claim. But nevertheless, that from my experience, would be the sort of circumstance that would still need to be reported, even though the client at this stage is totally unaware that there's the potential for harm. So sometimes the trigger is your own knowledge, or the policyholder's own knowledge of the standard of work that he's actually working on at that particular time.
It happens quite often.
So just moving on, Roger, you touched on the issue that most professional people, at least initially, would be reluctant to admit that if there is a potential claim, that they've actually got any liability at all. And again, from our experience, we find that the first inclination when something like this crops up is for the professional person to immediately spring to their own defence. And what they will quite often do is try and make the problem go away, so that then any potential claim fails to come back to bite them. So that is the first inclination that any professional person will have. It wasn't my fault. I don't know why you're blaming me. And they would immediately start preparing their defence and perhaps sending emails to their client to justify their position. And related to this is that any defence is likely to take rather too long to come to a conclusion, by which time it could be too late to notify a circumstance under the policy. This is the major problem that we come across, is the policyholder trying to solve the problem himself, and in the process making a bad situation worse. And now, Roger, you've got an example of this relating to an accountant. Could you take us through this?
Yes. Yes, you'll need to listen to this carefully. It's a true case, and it's a good example. This was an accountant that gave advice to his client. We'll call him AJ, and this was in 2012. And he was giving advice in connection with the release of equity in his company, and he wanted to do it tax efficiently, and he wanted the equity in the company because he wanted to build a new house in anticipation for retirement, I understand. So AJ took the accountant's advice and he built the house. 4 years after giving that advice, this was now 2016, HMRC knocked on the door and challenged the owner's tax declarations to the sum of nearly £800,000. Now, the accountant, in denial of the situation and quite confident of his own advice, set about challenging the HMRC on behalf of the client. And for 2 years, the accountant and his client, AJ, argued the toss with HMRC, but they didn't win. HMRC wasn't going to be moved. In 2018, AJ took legal advice, and he was advised to make a formal claim against his accountant. His accountant did notify his insurers at that time. At the same time, and this is an important side bit to this, just make a note of this, the broker, the accountant's broker, said, look, this is quite serious. You should make a very careful file of your of what's happened on there, because it's going to be examined by insurers and their lawyers. So set out the facts of the matter, don't hide anything, and just do a really good, clean job. Very, very good advice. The broker also advised the accountant to do nothing else, and especially not enter into further discussions with AJ, with his client. But the accountant, in denial, ignored the advice. And what they actually did, he actually offered his advice to act as his accountant for the next 5 years, free of charge. The assumption being, or presumption, will be you drop the claim against me. Anyway, upon examination of the history of this matter, the insurers had a field day because, first of all, there was late notification. The moment that the accountant had to challenge the HMRC and realised that actually this wasn't going to work, that was a notifiable circumstance. There's no question about it. And that was for 2 years. So they went through a renewal without mentioning this to the insurer. So that was misrepresentation, which allows the insurer, of course, to void the policy. So the fact is, it's a really good example of how the broker did the right thing. The insured notified, but didn't recognise early enough that the problem that he had could give rise to a claim. And here's the example, that he was doing something he thought he'd got right. HMRC said, we don't agree with you. And whichever way you cut it, you've got to accept that HMRC has probably got the power to persist and prove some degree of responsibility, liability, culpability, whatever word you want to use.
Roger, on that case.
Sorry, say that again, Michael.
Sorry, related to this case. While the accountant was negotiating with the HMRC, part of that process would have been the accountant justifying his own advice and his own actions.
Yep.
So I suppose not only would this be seen as a late notification, but it would probably also be in breach of the policy's requirement that the insured allows the insurer to conduct any defence. So
yes, it is. Yeah.
An additional prejudice may well have been caused by that.
Yes, I would caveat this though by saying, and you and I obviously know this, that there are occasions when it's quite right for the accountant to continue to negotiate with the insurer, with the HMRC, but our advice will be tell your insurer first and get their permission to carry on.
Yeah.
Because if you go back to the previous, I think it's the previous slide that had the word prejudice on it, and I didn't mention why it's there, but it's there because, as I said right at the beginning in the introduction, the insurer has an absolute right to expect the insured to tell him if there's likely to be a claim, because he wants to protect A, himself as an insurer, and B, he wants to protect the insured, of course. That's the bargain. And if the insurer doesn't know about it, he can't start the protection. But more importantly, if he doesn't know about it, an insured, an accountant in the situation he's in, is very likely to prejudice his and therefore the insurer's legal position by doing something or not doing something or saying something that the lawyer would say, no, for heaven's sake, don't do that, don't say that. We've got to preserve the integrity of our legal position. So prejudice is a very good reason, or avoiding prejudice is a very good reason for making early notifications. Now, I'm going to come back to what I said right at the beginning, that a lot of policyholders are terrified of making that notification. Now, in this case, making that notification early through a broker who was evidently as competent as the one that he had here would have been an ideal time to say to the insurer, look, I'm notifying you of this, but actually I'm very solidly convinced that I've got this right in tax law. I've taken, he might have taken counsel's opinion, for example, on the tax law on the matter, and therefore I've notified it to you. I would like your permission to carry on and negotiate it, and I'll keep you advised. And a half-decent insurer will say, yeah, okay, fine. They might well put a lawyer on it and say, keep the lawyer advised. But the point is, they're working together and you're avoiding prejudice. And that's the purpose of this. That's the purpose of this, if you like, tale, this example. Right. It's a very good example of just how convoluted these things can go. It's exactly the kind of thing that should be avoided.
Well, let's move on to another example. This time the policyholder happens to be an insurance broker.
Yes.
And he's got a client who's suffered a loss. A warehouse has been destroyed by fire. However, the claim was rejected and the policy was voided because the insurer alleged that a director of the policyholder had failed to disclose a past liquidation. Now, from our experience, whenever a broker comes across a situation where an insurance claim has been rejected, the broker will either recognize that it's quite right for that claim to be rejected, in which case he will explain to his client how that situation has arisen. But quite often the broker will feel that the insurer's decision to reject the claim was not sound. And in this case, the broker may well feel that there was no need for this past directorship of a company that had ended up in liquidation should have been disclosed in the first place. There's quite often a different point of view on that subject, and it's an issue, Roger, that we've mentioned from time to time in the past.
Many times.
That we find that many statements of fact that cover the issue of past liquidations are very, very poorly worded, which opens up to different interpretations. And it may well be that this broker looked at the statement of fact and advised his client, actually, there was no need for you to mention this past directorship. Now, of course, when the claim arose, the insurer took a different view. And these things can take many, many months, if not years, to iron out. So what the broker did in this case is perfectly understandable, because he felt that there'd been a travesty of justice. He felt the policy should not have been voided, and he felt that the claim should have been paid. And so he swung into action and spent 18 months trying to prove to the insurer that their decision was unsound. But in the end, he got nowhere. The insurer was unmoved. The policy remained voided. And with the result that the broker's client decided to lodge a claim against the broker, alleging that the broker's advice about whether or not to disclose the past directorship was the right advice or not. But the problem is, in this example, because the broker had never made a notification of circumstances to his own PI insurers, his insurers said, when he did finally notify it, I'm sorry, it's too late. Very, very similar to the accountant's case, because as soon as the broker recognized that the reason the claim had failed was because of the advice given about the past directorships, the broker should have recognized that as being a circumstance that could lead to a claim against him. And that's why we've referred to this as the cobbler's shoes, because of all people, brokers are in a good position to know when they should and when they needn't notify a circumstance. But when you're too close to the action, and when really what you want to do is to protect your client and to get the claim paid, you can overlook the need to make a timely notification. So we have actually seen this quite a lot. But when we find ourselves advising brokers about declined claims, we usually, if we've got the opportunity, have a chat just to make sure that the broker has not overlooked the fact that there could be some circumstances here that need to be notified.
Yes, I think it's very, very, very important. As you know, Mike, we've recently had a serious case of this type, and one of the issues that arose out of it was that the broker didn't keep notes of the discussions they'd had with the underwriters. In other words, they were saying to the underwriters, or the underwriters' claims people, you're wrong about this. But when they eventually failed, the client said, well, tell me what negotiations you had. What did they consist of? And there were no notes. Oh, we don't keep notes. That's not the way it works. Well, the broker had no defence, because the outcome was that the insured's claim was not paid, and they had a fairly solid claim of negligence against the broker for the way they conducted that matter on behalf of the insured. And we looked at it and said, well, there's not very much we can say. This is going to go to court. And it's a point we're making, is that the fear of making a notification is one of the reasons that people don't do it. And what we're saying here is that somehow it will be good for the industry, for us, if we can remove some of that fear. And the only people that can do that is the insurers and their legal advisors. If they want to put the fear of God into somebody every time they make a precautionary notification, then we're not going to get away from this problem. On the other hand, and there are insurers that do this, we know there are, who say, actually, I'd much rather know, but I'm not going to penalise you for it. I just need to know. All brokers of this class of business have come across people who have said that. That's the ideal situation, because it will encourage people to take care. I think it will, if they feel that in doing so, they're safe.
Yeah. Well, Roger, from the ground we've covered so far, I think we've identified that sometimes the biggest challenge is for the policyholder to recognise what a circumstance is. And we've just got a couple of additional examples here. Could you just go through this one for us?
Yes, well, this one, this is a contractor replacing roofing tiles, and as he's doing it, he discovers that the rafters are deteriorating and they won't support the tiles for very long. Now, that was not appreciated by the chartered surveyor or anybody else before ordering the roofing replacement. So that is a really good example, I would suggest, of a situation. There's a place I wouldn't want to be. This is awful. It's a situation you're in that you wish you weren't in. Now, the question is, was there any negligence there? The first place that one would look would be at the surveyor as to what kind of survey they did before the work was going to be done. Now, there was a survey in this case, we know there was, and the surveyor did look, but the surveyor said in his report, I can't give an opinion on things that I haven't uncovered. And fair enough. And he hadn't uncovered the roof. He'd been into the roof and hadn't discovered these rafter faults. And the question, of course, is whether they were reasonably discoverable by a surveyor in a roof space whilst the roof was still on. So the point is that it's a wonderful example of something that can happen completely innocently. Is it a circumstance that may give rise to a claim? Undoubtedly, unquestionably. Is it likely to? Probably not, probably solve it, but that's not the test that you can apply for yourself. That test is purely for the courts to apply, sadly, but it is, that's the way it works.
Well, I suppose one answer on this sort of situation, Roger, is for the whoever's provided the policy, whether it's the insurer direct or a broker, needs to develop the relationship with the policyholder so that at least there can be a discussion about these things. Because quite often there's a common sense answer. So, for instance, you could have a contractor who's put some slates on the roof, but they just happen to be the wrong colour. All right, well, that's going to lead to some dissatisfaction, but is it really going to lead to a claim for negligence? So, but the trouble is, if there's no dialogue between the policyholder and the whoever's provided the policy, then that opportunity to have a sensible discussion about it's never going to arise, is it?
No, and I think this is the problem. This is one of the problems. And quite often these things, they can drag on a bit, and very easily they can span across two periods of insurance, which is where the claims made bit becomes a bigger problem. Because the moment you're outside one policy period and into another, you've got all kinds of problems with regard to making a fair presentation of the risk and disclosure and non-disclosure and all that. And that's one of the reasons we're talking about this in the context of claims made, because the issue is made more difficult by the necessity of reporting circumstances or claims that fit within the policy period. Once they go outside of it, you're into a completely new problem, new set of problems. And that's just one example, and we can give you thousands of examples of things like that. And I think the important thing is that recognise that if you're in a situation you're in and you'd rather not be, that's a circumstance. In the context of insurance law and practice, that is a circumstance. And then the question is, how do I deal with this? And I think one thing that you've seen with what we're doing in our business the last few years, if you get these things early enough, things like that, you can solve without going anywhere near the law. As long as you can get a good dialogue going and say, okay, now we know this, let's get the parties together to agree X, Y, and Z. And that solves the problem.
I've thrown up a second example here about how to recognise a circumstance, because we tend to think of professional indemnity policies only being issued to what one would call the professionals. But quite often, these policies are taken out, for instance, by IT consultants. And so I wanted to include an example of an IT consultant who's doing the comms and the commercial retail business. And he's noted some abnormal level of interception traffic from overseas sources.
Yes.
And they increased vigilance and security controls and recommended an additional security consultant to investigate the source of the interventions. So they've noted a problem, they've done something about it, and of course the question is that a notifiable circumstance, or is it just an ordinary everyday occurrence? Because whatever business you're in, there are going to be ups and downs in every working day, and as soon as something goes wrong, it doesn't necessarily mean that that's a matter to notify to the insurers, but it might be, and this is the problem of identifying exactly what a circumstance is.
Yes, and in a situation like that, just from what you've said, if you break that down, if the IT consultant is charged with protecting the company, particularly against unexpected interceptions from overseas sources, and he's missed it, and it happens, then you could probably say that's pretty much likely to be a notifiable circumstance. If the interception is something that's never happened before, and it's been discovered, and the IT consultant says, right, well, I'll look into that, it doesn't strike me as anything more than good job he's there and he's on the pace. It doesn't strike me as a situation. He's just doing his job. It's when doing the job that they think they've missed something, or they've underestimated the power of something. So you've got to put these things. This is why all these things are fact specific. I'm sure somebody is going to ask us later on, here's a situation, is that notifiable? And the answer will be in advance, well, it depends on the facts. And sometimes it's the smaller, the neater, the tiny facts can make all the difference.
I think
fundamentally, the way to look at it.
Sorry, Roger.
Well, okay. Fundamentally, the way you look at a problem like that is, what are the facts and what are the consequences if this goes to the next stage? What are the potential consequences? Could they give rise to a loss or damage and therefore a claim? And if the answer is we can't see any loss or damage arising out of this thing, then the chances of it being notifiable circumstances are reduced. But the point about it being on a claims-made policy, it's incredibly important to recognise that the best thing to do, and really is the best thing to do, is to say, here's the story to the insurer. We don't think there's anything to worry about. Can we carry on?
Yeah. And
that's the way to go about it. And if the insurer says, I don't want to know, then that's another conversation. But
I do feel that it's very important.
It's such an uncertain.
I do feel it's important that the insurance industry retains a human element in these discussions with the policyholder. Yes. I'll give you an example. Yes. In an earlier life, I dealt with professional indemnity insurance for solicitors as a broker. But that wasn't just a matter of providing the policy and then leaving the solicitors to notify circumstances. I developed a system with my solicitor clients that if anything at all happened that they were concerned about, they would phone me up and we would talk it through. Actually, sometimes that had quite a useful confessional role. But the point is, it was a midway stage, so that before the solicitor decided that he had to put in a formal notification, it gave him the opportunity to talk it through. Now, I knew ahead of time that on at least 95% of occasions, I would end up recommending that the solicitor put in a notification. But that process of talking it through was very useful to the policyholder. And it developed an open culture of disclosure, which I think is very important. So whether you're dealing with a solicitor, an accountant, or indeed an IT consultant, without that relationship, it's very difficult to encourage that open culture.
Yeah.
So that it helps to get over that natural reluctance to notify a circumstance. If there's somebody friendly that they can trust, that they can talk it through, then it helps to get over that awkward barrier.
Yes,
But with
absolutely.
that, Rog, I think we ought to see if we've got some questions that need addressing.
Okay.
So over to Catherine.
Thank you, Michael. Thank you, Roger. Everybody's been listening diligently, and we do indeed have some questions. The first one is from Tim Nelson. He does say that what a great seminar that it is, and that he works in regulated financial business and makes notifications to PI insurers on any potential circumstance as a matter of prudence, as we should act as prudent uninsured until indemnity is confirmed and accepted by the insurers of the claim. He also advises that they have found communicating with insurers works well, notifying them of all these matters, which is a procedure that has not affected their premium or level of cover at renewal time.
Great.
And what he's asking is, would you agree those businesses working in a regulated environment are more sensitive as opposed to an unregulated firm or business?
Yes. Yeah, undoubtedly. Yeah, absolutely. A very interesting thing that we could run a webinar on its own is that virtually every form of industry, trade or commerce has its own culture. And some are risk aware and some are not. Some are risk averse and some are not. And underwriters, when they write a broad portfolio of business, get to know which one's which. And I would say that you're quite right, that regulated businesses generally, and there are always exceptions, but generally I think they are more aware. But what he says is spot on.
Could I just add to that by going back to when I was dealing with solicitors PI? You would have some firms, say a six-partner firm, that at the end of the year, they might have put in as many as 10 notifications.
Yeah.
There might be another firm of solicitors of a similar size that have put in none. And when I've discussed that with PI underwriters, they would take a more favourable view of the first rather than the second, because they would take the view that if a firm of solicitors is sufficiently aware of the need to notify circumstances, then it would be unusual for a firm of any reasonable size not to make occasional notifications. So the point is, this is underlining and supporting what the questioner is saying, that a good underwriter would not necessarily form a negative view just because there's a string of notifications. Quite the converse. To an informed underwriter, it tells them that the policyholder knows how it works and that they're playing to the rules.
I think, Mike, that's. I mean, I would say I had exactly the same experience at the same time. The problem we're getting now is that insurance is becoming more and more remote. There's less opportunity for even brokers to see underwriters. More and more work's being done on platforms or on email, and it's remote, and the communication is breaking down. And the outsourcing of claims is another issue. Gone are the days when you go and have a chat with the underwriter about a claim. And this is the problem, is because of the outsourcing of claims often means that the claims people have got no interest at all in the customer. They've only got the interest in batting the claim away and keeping the cost down. And this is a problem. I mean, it's a problem for the industry. So, and I believe, I'm going to say that I think that with the potential of AI coming into claims management and into legal cases, I think the situation will get worse before it gets better, because quite a lot of the best decisions about people's misfortunes are made by humanity. They're not made by an algorithm. And I think that's an issue that we've got to face. So what you've just said, it makes a lot of sense. And if underwriters and brokers can, between them, in this context, find a way of engaging with the policyholder to get the information which they need, they have a right to, and will avoid prejudice and all the things that come from that, then I think that's a journey that should be made more often than it is at the moment.
Yeah, thanks.
Thank you both. Richard Smith has asked, so as a broker, how does one get a policyholder to understand that they need to notify anything that may give rise to a loss? The problem being that in their own mind, they are, as you say, in denial and believe that they can fix the situation and it will not become a claim or a loss.
Well, the answer to the question, and Mike's going to have a go at this as well because he's very good at these questions. The answer to the question is how does a broker do it? That depends on what resource you've got, what time you've got, what incentive you've got, just to start with. But I can tell you, and Mike will tell you, it takes a lot of time, a lot of effort, a lot of dedication, and you can take horses to water, but you can't make them drink. And sometimes you can't persuade them. But I think the point is, I was talking to a broker last week, in fact, two brokers last week, big-ish firms, about very, very similar thing, this thing really. And they have demonstrated over the last 10 years now an ability to convey this kind of thing by very regular newsletters and webinars and things. And it's just communication and contact and building up a level of trust. And if you've got the resources, the time and the incentive to do it, that's the answer. Mike, what would you add?
The two things I would add. Going back to my solicitors, at the time that I was doing this work, I also was acting as a freelance journalist with the Solicitors Journal. And I was writing about solicitors' PI. And during the course of one of the articles, I invented a process by which we were recommending that solicitors completed a quarterly declaration.
Yeah.
So each partner would be required to complete a declaration of circumstances. Now, quite often it was a nil declaration, but it was a very good way of drawing out the information before it got too late.
Yeah.
Now, of course, that would be over the top for most professionals because genuine reporting of circumstances should be a relatively rare occurrence. But again, I know that time is money, but at least a half-yearly review with the client would do no harm. An opportunity to talk through with the policyholder what the requirements are. And again, doing it at the 6-month point rather than just immediately before renewal. It gives everybody time to just consider whether or not there's anything to report. And I think a half-yearly review together with a comprehensive review at renewal should be quite a good way of drawing out some of these issues.
It's a good point you make, and it's also something which leads to another point, which might be a useful tip for some people, is that when you're talking to the person in a company who is responsible for buying the insurance, don't assume that he has authority to know what's going on in his own company. And I can give hundreds of examples of this if I'm pushed to. But what often happens is it's a director or a company secretary or somebody, and he will say to you, as far as I'm aware, there aren't any circumstances that can give rise to a claim. But I don't know what's in the minds of the people that work in this company. And actually, what you've just said is, this used to be a pretty standard thing back in the 80s and 90s when I was doing it every day, is you'd say to these people, why don't you get a declaration or a thing around your company, do it with the board's consent, and get a consensus of people being able to talk about these things. Because the problem is, in today's society, it's not all right to talk about so many things. Because you can get your P45, you'll get sacked, or you'll get marginalised. So to go and tell the fact, I was dealing with a contractor, a very big contractor, only a couple of weeks ago, and the chap there, I said, look, why didn't this potential problem, why didn't it get talked about earlier? Because it's been going on for 4 months before you get on to doing something about it. He said, you can't do that here. You can't make those kind of comments, because if you make a comment like that, you're making an assumption or an assertion that somebody's failed, and you can't say those kind of things. So that's the kind of problem we're dealing with. That's actually a new risk, funnily enough, for the insurance industry. The fact that people can't talk about things means actually things are being suppressed. And it's showing up all over the place. So I think what we've got to look at in the context of how we do these things in the future is to keep in a very open mind, in the context of, we know that with technology is keeping a lot of communication out, because if the fact or the matter isn't sort of talked at the water cooler, then it doesn't go through the algorithm. And as you know, Mike, we're talking earlier on about the directorships. This problem with, well, you know that your wife ran a laundry business that went into liquidation in 1958. If I'd known that, I wouldn't have written the risk. Well, that's because technology is taking away the communication between the customer and the insurer. And so the question we had just at the moment, how do you restore it? I don't know. It's going to be increasingly difficult, because technology and expulsion of humanity is getting in the way. It's a real conundrum. And I don't see anybody in the insure tech business focusing on that problem. They're all focusing on the transaction, or the bit where you've got monetary profit or gain.
Sorry,
Yeah,
have we got time for one last question? Because we need to wrap up fairly soon.
Yeah, okay.
We do have a question. I think it was referring to one of the cases, the second one, from a Stephen Challoner, who asked, should the accountant's broker notify the insurer?
Should the accountant's broker notify the insurer? Well, only if the accountant asks him to. The broker is the agent of the client, not the insurer. And if the broker notified the insurer without the permission of the client could reasonably complain. Well, that might sound a good idea. He shouldn't do anything without discussing it first with the client. But he can, if he's told to, yes, he can notify them. But can I just say this? Right at the beginning, we talked about the word claim. Yeah? And we did that because you've got to, if you're doing that kind of thing, you've got to know what the rules are. And that's why if you look in the policy and see where the word claim occurs, it will often occur with a capital letter under claims notification. What is a claim and how do you notify it? And one of the things that happens time and time again is people don't notify in accordance with the terms and conditions, and it gets chucked out. And that's why we mentioned it. A claim and a claim can be two different things. And so you've got to be precise as to know what you're doing.
Very good. Well, I think we've run out of time, unfortunately, Roger. So do watch out for the notification of our part 3 in this series, when we'll be looking at just one or two aspects, such as runoff and retroactive dates.
Retroactive cover, yeah.
And we'll also be looking at the may, likely, could issue. But
and
as
if
I say,
you've
we will
got
allow more
questions
time for...
Yeah. For more questions, if you like to prepare them in advance, perhaps, come along ready. We'll give you as much time as we can to.
Okay, so
thank you.
Thanks for coming along.
Thank you very much for both delivering this webcast today, and for all the information you shared. As the session, as well as the first webinar in the series, will also now be available on demand. And please feel free to share this webcast with anyone you think would benefit from it. Thank you to all the delegates for joining us today. Thank you, Roger. Thank you, Michael. Bye-bye.
Okay, bye-bye.